Hey guys, it's Michael Sutton with Michael Sutton and Associates, part of Keller Williams Realty La Jolla. Today I had the honor and the privilege to interview an estate planning attorney. She handles estate planning, forming of trusts, and this can help you, especially those of you with families, with kids, avoid the probate process, which can be time consuming and costly. And who wants to deal with getting, the courts and the government wrapped up in your family affairs? Nobody, right? So check this video out. Hope you learn some things, and feel free to reach out to me for any questions regarding real estate or anything else. And feel free to reach out to Leanne, who I have featured in this video, if you're interested in forming a trust or getting an estate plan done. Thanks so much. Hope you enjoy it. Hey, this is Michael Sutton with Michael Sutton and Associates with Keller Williams Realty La Jolla. I am here. Joined with me today is Leanne Barbat Maestre.
Got it.
Maestre. Tough name to say. Leanne, thank you for being with me today.
Thanks for having me. I'm excited.
Of course. I appreciate you taking the time. So for you guys who don't know, Leanne is a partner with Kimball, Tirey St. John. They're a law firm here in San Diego. They work and do things with tenant landlord law. They also have a business real estate group, and Leanne is part of the estate planning group within the business real estate group. She's practiced law for 17 years. It's a long time. And she's a member of the Probate Attorneys of San Diego. Is that right?
That's right. Yeah, it's a great group.
Oh, that's awesome. So can you tell me a little bit about that group and kind of just about your business and what you do?
Sure. So, the Probate Attorneys of San Diego is a group where a lot of local counsel get together, even with the local judges, on a monthly basis to discuss new laws, new case law, and better ways to maybe make the estate planning process go, or how we handle probate matters or trust administration. So it's a great group to be a part of, especially if you're a probate attorney.
Oh, that's awesome. You mentioned something in there, Leanne, about estate planning, and that's exactly what we're kind of talking about today, or not kind of, that's what we're going to talk about today is estate planning, living trusts. And being that I'm in real estate, this I know for a lot of people who own real estate can be extremely beneficial, and there's a lot of protections that it allows. And I'm going to go ahead and let you, the expert, elaborate more. So can you kind of tell us about the estate planning process and what some of the benefits are with that?
Sure. So when a client comes to me and wants an estate plan, I explain to them what it is. So what our estate plan includes is a living trust.
Okay.
And we'll touch base on exactly what that is: a pour over will, advanced healthcare directive, and a durable power of attorney. The living trust is the biggest ticket here, biggest ticket item. This is to really protect your heirs and your beneficiaries from the probate process, which I know we'll touch on a little bit later. And this also provides you, the trustor, the one who's creating the trust, basically the power to determine who is going to be in charge of your estate, who will receive your estate upon your death. And when I say in charge of your estate, not only upon your death, but if you become incapacitated, which is really important because you don't want just anybody to be in charge of it.
So what would be an example, Leanne, of being incapacitated?
Well, typically what we have in our documents is if two of your doctors deem you incapacitated, meaning that you can't make any decisions concerning your finances or concerning your health, then really you shouldn't be in charge of your estate at that point. You should really have somebody else take care of it for you.
So maybe if you're in a coma for a long time or in an accident where you've got some brain damage or dementia, Alzheimer's disease.
Exactly.
Okay, cool. So basically, by having this estate plan and trust in place, you are deciding while you are of sound mind, sound body and mind, who's going to get the property, the money, and get everything, that all of your assets, as well as how they're spread out. And then also it protects them from having to go through the probate process.
Exactly. And so along with that, you have what's called a pour over will, so that if there is anything that you did not fund into the trust, then the will takes care of that, as it specifies everything will go through the trust. but you still have to file a probate proceeding, which we want to avoid.
Okay, cool. And so basically, if just to make sure, it sounds like that pour over will is could be really beneficial. So if you were to acquire some stocks or assets that you didn't add to your trust or your estate, and you got in a car accident, it would still be protected from the probate process. Is that correct?
Not from the probate process, but it'll be protected from who will those assets be distributed to. So, because really, if you don't have any indication or anything in writing, like a will or a trust as to who your assets go to, then California law will determine that for you.
Oh, okay. So instead of having it go and be determined by the court system, it will still go through probate, which means going through the court system, but there will be the pour over will, and it'll be pretty clear cut for the court to say, okay, this is who it goes to.
Exactly. And that's why it's super important that after you talk to an estate planning attorney and have a draft of a trust created and sign that trust, that you fund the trust. So you make sure that you transfer those bank accounts, your stock, those properties into the trust. And I can help with the property, but you have to take the lead, the initiative to go ahead and transfer your other items.
Okay, awesome. And so, we've mentioned probate a few times, and being in real estate, of course, I'm very familiar with the term, but for those who aren't familiar with the term, who might be watching this video, can you elaborate on kind of what probate is and why people like to avoid it?
Sure, absolutely. So if you don't have a trust and you have a will or you don't have a will, then you have to go what's called through the probate process. The probate process is basically dealing with the probate court. And dealing with the probate court is a long, long period of time before any heir would receive their distribution. It's also very
costly as well.
And expensive, exactly. Because you're paying the attorney their statutory fees or any extraordinary fees, you're paying costs, and you're waiting this entire time before your heirs can receive their distribution.
And how long, I know every case, I imagine is very different, but what would you say is a typical or kind of average time that it would take between starting the probate process and the heirs actually receiving whatever money, property, or assets that are waiting for them?
Right. So typically now it's about a year and a half.
Wow, that's a long time, a year and a half.
It is, and I'll tell you why. So initially when you file the probate, you file a petition for probate, but you can file that, but the court won't hear it for another 4 months. So it's really the court calendar that is bogged down, and which is why there's no hearings that are much sooner than maybe 4 or 5 months, which is why there's always a delay in probate.
Okay, wow, that doesn't sound very fun.
No, which is why it's so important if you're living in California to have a living trust, especially if you have assets that are worth over $166,000, because that's the threshold for when probate is filed.
So the threshold is $166,000.
It's $166,250. But if you own real estate, and I believe the threshold is, I think, $50,000. So
well, I was going to say, even if it was the higher number, there's nothing in San Diego that's going to cost that.
Exactly.
At least nothing I'm working with. And so, so it sounds like, so let me ask you this. So if I have kids and I were to have my property in a trust with a estate plan and will in place, and I have some unfortunate accident and I, happen to pass in a car accident or while traveling or anything like that, then what would be the time that it would take to be able to transfer my assets that are in the trust, my property, money to my heirs, my children?
Much more, much less than a year and a half. Your trustee will then pay off your creditors, pay any taxes that are owed. And then even in the meantime, you can receive a partial distribution, or your heirs can receive a partial distribution.
That means you get part of it?
You can get part of it if the trustee feels like they have enough assets there to pay the creditors and taxes.
Okay.
And that can happen in probate too, but you have to ask the court for permission.
Oh, okay. And we all know that doing anything with the court or any kind of public run system is timely
and costly.
And
right.
Usually not the most fun.
Right. So yeah, I would say, I know a lot of beneficiaries of trust want their assets immediately, but certain things have to happen.
Okay.
But I would say maybe in every case is different, but in a general case, maybe 6 months or less.
Okay, so basically it's half of the time or less than half of the time.
Absolutely. And the cost is significantly less.
When you say significantly less cost, what are we talking?
So 2021, we are charging a married couple $2,500 flat fee for a trust. So for the living trust.
This is what it costs to get a trust set up.
Correct.
That's
for the estate plan.
What if you're single?
Single, we charge $1,750 flat fee.
Okay, so you're just basically $1,750 per person to set up a trust.
Correct, but I mean there are costs, and then those are nominal. You have to have a notary sign some of the documents. You pay the notary for that.
But there's a few other costs similar to like closing costs in real estate that are associated.
Not that much, no, just a little bit.
They're on the same level, but they're I'm trying to relate it on the way.
Yes.
There are some other associated costs, but what do you think all said and done for a married couple to set up a trust? Maybe about what, $3,000?
Less.
Less than $3,000. And what if we have to, or someone has to go through probate? What would that end up costing the heirs?
The statutory fee pursuant to probate code of California. So it depends on the value of your estate. If I'm not mistaken, I believe $1 million estate is running, I believe, about $10,000. So it is more. It is more than what we charge for a trust.
Wow. So $10,000 is like the minimum is kind of what it sounds like to me.
Yeah, I mean, I can pull up really fast probate code for attorney's fees. It's statutory, and it's definitely more costly. So it's like 1% of the first 100,000, 2% of the next 300,000. But it's costly. It is.
And it takes a lot of time. And then are there court appearances that the heirs would need to be present for as well?
If there's no oppositions or objections, and I'm going to correct myself. So the first 100,000 they charge 4% pursuant to the probate code. So that's $4,000 if your estate is worth 100,000. But obviously, you're not going to file probate if your estate is only worth 100,000 unless you have real property. The next 200,000 or 100,000 is another 3%. So if you have an estate worth $200,000, the attorney's fees are at least $7,000.
So and we know that a lot of homes, I mean, the, median house price in San Diego just keeps going up and up. And, we're at that point where we're, in the 700,000s, approaching $800,000 mark for the median price house, right? So a lot are more than, and if a family has more than one property, it's going to exceed that. And then you had mentioned if there were no oppositions, and one of the things that's unfortunate, but is the reality of what I've experienced in real estate, is a lot of times when you have several heirs to a property, there tends to not always be a meeting of the minds, let's say.
Yes.
So there is oftentimes opposition.
Unfortunately, yeah. Some of the beneficiaries, when there's money, people get greedy sometimes. And
yeah, which is unfortunate. So if you don't want your loved ones fighting over your money after you pass or incapacitated, get a estate plan done.
Absolutely. Right. And to say that, I mean, there are obviously disputes in a trust, where certain heirs dispute with, what's specified in the trust. But yes, it is best to try to keep the court out of your life, I
agree. I mean, I would think that the majority of people would say you don't need the government to help you decide what's best for you and your family.
Right. And you should be in charge of that. And that's why it's important, like you said, when you're of sound mind, to make that determination. Who's in charge of your trust? Who do you want to receive your assets upon your death? So it's important.
I appreciate you saying that. It brought a question to my mind. Let's say that I set up a trust and, one of my kids, winds up with the wrong crowd, and I don't really I change my mind about them because I don't want to give them, or whatever the reason may be. Can I change my trust in estate plan?
So in a revocable trust, you can absolutely change it. You can amend it as many times as you want. I've seen somebody amend it 15 times. And
Wow.
there are special provisions that you can make in a situation like that. For example, if you do have a child that is, into drugs or alcohol or something, you don't want them to have an outright distribution, you can have it held in trust for his or her life. So there's different creative ways that can be written in a.
So it's distributed in like an allowance, or
If you can create it, so you can have it maybe based on what the trustee determines, up to their discretion.
oh,
It's typically for what they call like housing, health, education, and maintenance for
okay.
that individual. So because you don't want that individual obviously to use it for drugs or alcohol.
Of course. And so it sounds like that these trusts and estate plans can kind of be as creative and as customizable to your unique situation, really, as you need. Would that be fair to say?
Absolutely, every family is unique. So
that one.
yeah, and so there are different. With that.
I said I love you, mom and dad.
Yeah, I know. And it's just every trust is unique, and we can customize it to what that situation is. And there's a myriad of different trusts. There's a special needs trust if somebody's on government benefits, so that the government benefits aren't taken away. There's what's called an AB trust or bypass trust. So there are different trusts, and what we specialize in is mostly middle income families. And we typically handle the revocable living trust. But there are a lot of great attorneys in San Diego that can help the high net worth clients with the complicated trust.
Okay, cool. So you guys are handling more of the stuff for what you described as like a middle income, average family, not someone with a huge portfolio of assets and stuff like that. Right. However, there are people that you could, I'm sure, refer out if right. you. Okay, great. And so kind of the thing for me being in real estate and serving so many people here in San Diego that have families or that end up having children and growing their families, I have really started to encourage them to look into getting a trust. Mm-hmm. In the last just short bullet points, why would you say it's important for those, especially with children, to have an estate plan and a living trust?
Absolutely. So especially those with children, you can name a guardian in your estate planning document so that there's no confusion if mom and dad are both gone, who is to take those children in and support them. So that's important, especially if you have children. Like we stated earlier, a living trust is important so you can avoid the probate process, avoid the long drawn out probate process, court process, and save money, by not having the court involved. And mainly being in charge. Who is going to be in charge of your finances? Who can you trust with your checkbook the next day to appoint as your successor trustee? And who do you want to leave your assets to? It doesn't necessarily have to be your heirs. It could be charities. It could be something that you're passionate about. So it's important to have an estate planning done completed. And I would encourage everybody to do it. Even if you don't own property over the threshold of probate, have a will, have a power of attorney, have an advanced healthcare directive, because God forbid you have some time where you are incapacitated and you're going to need someone to make that decision for you regarding your health or your finances.
Well, Leanne, thank you so much for that. It sounds like if you've got people you care about and you've got some assets, get an estate plan done so you can take control while you're of sound body and mind to have a plan of where your money is going to go, where your assets are going to go, where your kids will go, and who will take care of them. And just when you're not here to make those decisions, you've got a security item set in place to make sure that your will is executed after your passing or incapacitation.
Exactly. Yeah.
Awesome. And Leanne, if people want to get a hold of you and ask you questions about the estate planning process or even get started with an estate plan, how do they get a hold of you? How can people contact you?
Absolutely, and I appreciate you asking that. They can call me on my direct line, 619-881-4898. You can actually Google my name and you'll find my contact information on our website. So it's easier. They can contact you, especially if they want to purchase or buy a home or create a trust.
Oh, well, thank you. I mean, people are always welcome to, call Michael Sutton with Michael Sutton Associates, Keller Williams Realty La Jolla. We help you buy, sell, invest in real estate, help you consult and plan, and
Amazing at it.
help you with your estate plan.
Yeah.
Well, Dan, I really appreciate you taking the time with me here today. Thank you so much.
Absolutely. Thank you for having me.
Of course. Well, you take care and we'll be talking to you soon.
Okay. Bye.
Hey guys, if you like that video, please like it, subscribe to my channel, and if you want to get a hold of Leanne, you can find her at www.kts-law.com. Have a good one. Thanks for watching.